Good afternoon, everyone. My name is Rachel Napoli, and I'm the paralegal to the phone CLE COSAR James Schmidt at James A. Schmidt, PA. Mr. Steve Hogan will be our presenter today. Mr. Hogan is a shareholder with Ausley McMullen in Tallahassee, Florida. His practice focuses on tax litigation, commercial litigation, and commercial drone law. Mr. Hogan serves as co-director at the Tax Section State Tax Division and as an adjunct professor at the Florida State University College of Law. We will leave about 10 minutes at the end of his presentation for any questions or comments. In the meantime, all callers will be muted. I'm very glad to hear him present today. With that, Mr. Hogan, please take the lead.
Thank you, Rachel, and thank you for your help setting all this up and coordinating everything. It's always wonderful to be able to just jump on the phone and have everything work out. So thank you for your help here today.
Absolutely.
And before we jump into today's topic, for the benefit of everybody on the phone, here is your CLE course number. So that was your cue to pick up your pens. This is your CLE course number, and it is as follows: 17029110N. I'm going to say that one more time: 17029110N, as in no. We'll repeat that towards the end before we open things up for any questions that we may have from the people on the line. So once again, thank you, Rachel. Thank you to the tax section, and thank you for everybody that's on the call here today to hear this talk about statutes of limitation in Florida sales and use tax audits. So what are we talking about with statutes of limitations in Florida sales and use tax audits? Why is this even an issue? It would seem from a instinctive level anyway, that the statute of limitation is just the statute of limitation. You know, whatever it is, that's what it is. And why is this complicated? Well, it's complicated for a couple reasons, one of which being the peculiar way that statutes of limitation work in the tax context. And when we're talking about the tax context, we're talking specifically about Florida Department of Revenue audits of businesses for sales and use tax compliance. Now, of course, there are other different types of taxes out there that the Department of Revenue, the Florida Department of Revenue audits. This particular presentation is going to be discussing the implications in the sales and use tax audits, because that is where the complications are most evident with regard to statutes of limitations. But of course, these principles can be extrapolated to other types of Florida tax audits, but they may have different specific issues depending on the way that the tax returns are filed. And that'll make sense as we go through this. So let's take a look here. Sales and use tax. When we talk about sales and use tax, is it that we're talking about? We're talking about the tax on transactions, most transactions in the state of Florida, where you have a sale of a piece of tangible personal property, or the sale of an admission, the sale of the right to occupy some space, where you have a commercial rental tax. That's all in the purview anyway of sales and use tax. So, of course, commercial rental tax is slightly distinct, but if you're collecting and remitting that tax, you're filing returns on a regular basis. So I would say the analogy holds. So sales and use tax is one of the most common types of taxes that you find in the state of Florida. It's almost half of Florida's budget comes from sales and use tax. And so you get sales and use tax audits as one of the most common types of audits that Florida businesses face. Now, when you look at a sales and use tax audit, when one occurs, the general 3-year statute of limitations applies. And this general 3-year statute of limitations is found in Section 95.091 of the Florida Statutes. That's Florida Statutes Section 95.091. And that provides the general statute of limitation for taxes, for the state of Florida to assess tax against a taxpayer. And for our purposes today, the important piece of that general 3-year statute of limitation is when that limitation period begins to run. And The statute, section 95.091, begins to run from the date that a tax return, whatever tax return it happens to be, is due to be filed or is actually filed, whichever is later. So setting aside for the moment the question of when particular tax returns might be due or when they might be filed and how that might impact specific taxpayers, let's just look at it as a general principle that it's the filing of a tax return that triggers the statute of limitations applicable to the taxes that were due upon filing that return, right? Now, why does this matter? Well, for sales and use tax, this really matters, this date of filing or the date the filing was due, because for most businesses in the state of Florida, you have a monthly sales and use tax return that must be filed. So that means that every single month, most businesses, almost across the board, are going to be filing their what's called a DR-15 tax return. That's just the name of the form. And you can find a sample DR-15 on the on the Department of Revenue website. Most taxpayers, though, file them electronically. But whether it's filed electronically or on paper, the return is due for most taxpayers every month. And a question that might be in your mind is, well, what do you mean most taxpayers? And what I mean is, if you have certain volumes of sales, you may only have an obligation to. You may not have the monthly obligation to file. You may be on a quarterly basis, for example. But that's all spelled out in the statutes. But most businesses have a monthly filing requirement with their DR-15 returns. So what that means then is that every month when the DR-15 return is due, that means that a new 3-year statute of limitations is triggered for that particular return, for the amount of tax that's due for that specific month. And so you essentially you can visualize this in your head. Every month in the year, a new 3-year limitations period is spinning out from that month. It almost like trails behind it, like I don't know, like a string maybe. Look at it that way. The string is 3 years and it flows off of that month when the return was due. So as these things stack up in time, what you end up with is almost a stair step of limitations periods that hang off each month as it goes forward. And I don't know if that's the most artful analogy, but when I've explained this to people, I tend to draw a picture. So I don't have a picture for you here today. So hopefully the word picture that we're drawing is good enough for you to grasp the concept. So we have this monthly filing requirement and a 3-year statute of limitations that's triggered by the filing, or at least the filing obligation. So we have a 3-year limitation period for each month for each monthly return, okay? Now, let's take that concept and move it into the context of a tax audit. Now, if you've gone through, I know we have probably just lawyers on the phone here today, so if you've ever helped a client with a sales and use tax audit, you may have noticed that the Department of Revenue opened a 3-year audit period. And that makes sense. If you're the Department of Revenue, you want to audit all the way back as far as your statute of limitations will allow you to go, right? So it makes sense that the Department of Revenue would open up a 3-year or 36-month audit period. That just makes sense. But wait, you might think, if we have these cascading limitation periods, then the oldest month in that 3-year period has a limitations period that's about to expire. It's almost like a burning fuse. So if I start my tax audit at time 1, let's call it time X, and the audit period goes back to 3 years prior to time X, then that first month in the audit period is going to expire then as soon as a month goes by. So if that was the end of the story, then what you would have is the Department of Revenue would be functionally unable to audit a 3-year period because nobody can do a tax audit in 1 month, right? So that's what we're dealing with here. So how do we get around that? What's the solution to this problem? What is the solution to this problem? Well, the solution to this problem is that, actually, before we go to the solution to this problem, let me bracket that for a moment and just mention something else. So with this, the normal situation, if you read the statutes in the way that they make sense, you have these cascading limitation periods, right? That is the subject of our talk today. There's a different set of circumstances that may appear if a taxpayer, and I thought everybody's line was muted, but if there's anybody that doesn't have their line muted, if you can go ahead and mute your line, so we can sort of hear you on the speaker, just as an FYI. Okay. Now back to this exception that just to tell you what we're not talking about. A taxpayer and the Department of Revenue can mutually agree to extend a limitations period that would otherwise apply to an audit. Okay. The way that you do that is that you execute an agreement which is formalized by the Department of Revenue's Form DR 872. And what that agreement will do, and you can find versions of this around, I don't think it's readily available on the Department of Revenue's website, but you can find them. What a Form DR 872 does is extend the statute of limitations for a tax audit, and what that does is create a date certain endpoint that by agreement the taxpayer and the department agree that date certain becomes the one limitations period that applies to the entire 3-year audit period. Okay, so that is done by agreement. That's done through that form, and that is not the limitations period that we're talking about here. Okay, in the context of this discussion, there's a different set of circumstances that may apply when you when you have a Form DR 872 extension agreement, and those are pretty routine to enter into because sometimes an audit takes a while, and both the taxpayer, it's advantageous both to the taxpayer and to the Department of Revenue's auditor to extend the deadline so we're not in a time crunch, so we can help get to the right answer instead of a quick answer. Sometimes that's the best for everybody. So if you remember the Verizon business purchasing case from 2015, that case was dealt with statute of limitations issues, but the limitations issue in that case was fixed at one point, at a point certain, if you will, by a DR 872 agreement. So just for sake of clarity, we're not talking about DR 872 agreements and the fixed point in time limitations period created by those in this talk today. Okay. So let's wrap back around to where we bracketed out. So we have this problem of cascading limitations periods applied to each month. So how do we fix that? What do we do about that? Because it's clear that the Department of Revenue cannot audit a taxpayer for a 3-year period in 1 month. Well, what the Florida statutes create is a tolling period, And if you could see me, I'm putting tolling in scare quotes because what we're really talking about today is what the meaning of tolling is, what it means under this statute. Now, the statute that's in question here that creates the tolling provision is Section 213.345 in the Florida statutes. That's 213.345 in the Florida statutes if you're following along at home. And this tolling provision says that the limitations provision that's set forth in Chapter 95, which we talked about, that's the general 3-year period, shall be tolled, and I'm reading the text of the statute here. It says that that 3-year period shall be tolled for a period of 1 year if the Department of Revenue has, and I'm skipping over some language, issued a notice of intent to conduct an audit or investigation of the taxpayer's account within the applicable period of time. So there's some important language there. First, that 3-year period shall be tolled. Okay, and what does tolled mean? We'll talk about that in a minute. For a period of 1 year. So you've got a year here where the statute of limitations is not going to run out while the Department of Revenue conducts its audit. So that gives everybody some breathing room, okay? As long as the Department of Revenue has issued a notice of intent to conduct an audit, and that's a form that a taxpayer will get. It normally is a form that says a notice of intent to conduct an audit of books and records or something to that effect. That puts the taxpayer on notice that the Department of Revenue is coming and wants to see their books and records, and an audit is going to occur. So when that notice goes out, that triggers this tolling period, okay? And the Department of Revenue has 120 days then, according to the statute, to start the audit. If the Department of Revenue, we're not going to get too much into the 120-day issue here in this talk, but if the Department of Revenue doesn't start the audit within 120 days, then that tolling period, quote, shall terminate. So if the department wants the benefit of the full 1 year, the department must start that audit within 120 days of sending that notice. Okay. So we get a tolling period. Now, what does it mean to have a statute of limitations tolled for 1 year? And it may seem like, well, what does it matter? Doesn't everybody just know what tolling means? Doesn't it just mean that, things are on hold? Well, to a certain extent, yes. Then the question is, what happens after the tolling period's over, right? Because if the Department of Revenue gets the audit assessment out within that tolling period year, then there's no question to ask. And there's no more work to be done, at least on this issue. Because it's clear, at least to me and to people I've talked to about this, that if you're within that tolling period, the statute of limitations is certainly not going to run out. So if the audit assessment is issued within that 1 year, then there's no problem with the Department of Revenue assessing the entire 3-year period. Okay, but just as a thought experiment, and this has happened in more than one case. You get the Florida Department of Revenue not issuing an audit assessment within that year. And if we rewind back to the Verizon business purchasing case in 2015, the issue in that case, the main issue, was whether or not a notice of proposed assessment, or a NOPA, as we say in the biz, whether or not that NOPA itself was an assessment that would count for purposes of the statute of limitations and the Department of Revenue timely issuing an assessment against the taxpayer. Because when a NOPA comes out, it doesn't become a final assessment, well, at least under the Verizon business purchasing case, that clarified that the NOPA itself is not a final assessment. And if you have ever seen a NOPA, you will see on it that it says that it does not become a final assessment until 60 days goes by. So what you had was the Department of Revenue issuing a NOPA and with less than 60 days to go on the tolling period. And that means that if you just waited out the clock as a taxpayer, then the final assessment would, by definition, not have been issued, could not have been issued until after the tolling period had been used up, after that 1 year is gone. And the question becomes, well, what now? What has become of our original statute of limitations? And there's really, as I see it, two potential ways to look at this. There's two potential legal consequences of this dynamic of a final assessment not coming out until after the tolling period is over. And if somebody out there on the line can think of a third, I would love to be enlightened. But so, please drop me a line. But here are the two options, and you've probably already created them in your head because I know there's a bunch of smart people out there on the line. Option one, if you will, is does that tolling period add time on to the limitations period? Does that tolling period push pause on the statute of limitations that would otherwise be running, and then after the tolling period is over, is it like unpausing the statute of limitations so you have the entire 3 years now starting up again at the end of the tolling period, like the tolling period never happened, or excuse me, like no time had gone by. So what that would do in effect is when the tolling period is triggered, it would essentially create a 4-year statute of limitations, because you get the 3-year statute of limitations, it's paused for a year, so that adds another calendar year on to the time in which the department can assess, and then once the tolling period is over, you still get the benefit of that full 3-year period, however much of it wasn't used up before the tolling period was triggered. That's one option. Okay, that's one way to look at it, perhaps. The other option, and this second option is the one that, for the sake of this talk, I will take a position. I think the second option is better supported in the case law, but of course no court has pronounced upon this. Okay, so this is an open issue, if you will, and it's subject to argument. And I do invite counter argument. I mean, I've written about this in the Florida Bar Tax Section's bulletin, and at the end of that article, I invited counter arguments, because this is not something that's been pronounced by a court, and that means that there are arguments that could be made. So anyway, with that disclaimer, so you know my bias, if you can call it that, is that this second option is probably better supported than the law. And what is that second option? It's that the original 3-year statute of limitations would still be in place. Okay, if we imagine that this 3-year tolling period had continued to run, this 3-year limitation period had continued to run, had continued to be used up, and all the tolling period means then is that if the Department of Revenue issues an assessment within that tolling period, then the statute of limitations that would otherwise have cut off some of those months that are under audit from being assessed, well, that tolling period means that statute of limitations wouldn't bar an assessment of those months that would otherwise be time barred, right? And so under that view of how the law would operate, then when the tolling period is over, then it's like it had never been there in the first place, which means that if a year had gone by, let's just use easy numbers. Let's say that the tolling period started on day 1 of this 3-year audit period. Okay, the tolling period starts on day 1 and ends 1 year after day 1. All right, an assessment comes, the assessment comes out the next day. All right, then what that would mean, under the law that we'll talk about here in a moment, what that would mean then is that the Department of Revenue has lost a year, or is unable to assess now that first year of the audit, because remember these 3-year limitations periods apply to each month separately. So that means that every month that goes by in this 3-year audit period that's been opened up, or every month that goes by during the audit, you're losing a month. So if a year goes by, you've lost 12 months. Month 1, you lose month 1. Month 2, you lose month 2. Month 3, you lose month 3, and so on. So if a year goes by and you don't assess within that 1-year tolling period, then you've just lost 12 months of, if you're the department, you've lost 12 months of your ability to assess tax against the taxpayer. So that's the second way to look at it. And again, if you can think of a third one, I would love to see it. I think that would be interesting. So, what is this law then? Why do I say that I think this is better supported in the law? Well, there's several principles that go into this. And the first principle is well established in the case law. And that principle is that taxing statutes must be construed strictly against the government. And there's tons of cases you could cite for that. And I'll say that again in case that's unfamiliar. A taxing statute under Florida law, and this is Florida common law essentially, is that Florida taxing statutes must be construed strictly against the government, all right? That means if you have any ambiguity in a tax statute, then that ambiguity will be construed strictly against the government's ability to issue an assessment against the taxpayer, right? Of course, the corollary to that is that if there is an exemption in the tax law from the tax, if there's a tax exemption or a tax incentive, if you will, a tax credit, then those are construed strictly against the taxpayer. So it's kind of a tit for tat thing. If you have something that gives power to the government to extract money from the taxpayer, then that's construed strictly against the government. If you have a statute that gives a taxpayer the ability to not pay a tax one way or the other, whether it's an exemption or a credit or an incentive, whatever it may be, those are construed strictly against the taxpayer. So there is some equity there. And if we take that concept and apply it to this question, what you have here is an ambiguous taxing statute, because recall the tolling period is in section 213, is in chapter 213 of the Florida statutes, which are the tax administration statutes. So I would argue that the strict construction idea runs against the department in chapter 213, just as it runs against the department in any chapter that levies a substantive tax against a taxpayer, like say chapter 212, which is the sales and use taxes. Which, I mean, this is a sales and use tax audit talk, so let's just go with that one. So chapter 213, I would argue, has the same sort of construction levied against it, or layered atop it. That's probably a better way to say it. So when we take it there, and we have acknowledged at the start of this talk that we have an ambiguity, well then any ambiguity there has to run against the department, right? Has to run against the state, right? So it's clear that in those two options that I set up, option one being essentially giving the department or the state of Florida a 4-year limitations period versus the option two that we discussed, which says that now it's a 3-year limitations period and the tolling period just acts as a safe harbor for the department to issue an assessment. Then it's clear that option two is better for the taxpayer, right? And if you're construing this tolling period strictly against the government, it would have to be option two. That would be the construction that a court would adopt. So that's the first principle overarching on this discussion that underlies the reasoning. But that's not all of the reasoning. Okay. There's not a lot of case law out in the world on what tolling provisions actually mean. When I started to look into this, it was somewhat surprising to me that there was such a dearth of specific authority on what happens when you have something called a tolling provision that stops the statute of limitations from running. I mean, it's almost like courts say the word tolling provision and then move along as if everybody knows what it means. But it's not so well fleshed out in the cases. But there are a couple cases that provide us some guidance here on whether option one or option two might be the way that a court faced squarely with this problem might decide. So the first case that I'd like to mention here is a case called Ramirez versus McCravey. And the citation, again for those following along at home, is 4 Southern 3rd 692. That's 4 Southern 3rd 692. That's from the 3rd DCA in 2009. Now, this is not a tax case. This is not a tax case. This was a personal injury case, actually. And if you remember, back in the early 2000s, we had a lot of hurricanes run through the state of Florida. If you were in our state during that time, I'm sure you have vivid memories of this. It was hurricane after hurricane after hurricane. Thankfully, we haven't had that situation in recent years, but that was certainly the case back in the early aughts. Why am I saying this? because those hurricanes play into the facts of Ramirez. So in Ramirez, the plaintiff in a car accident case filed their lawsuit 3 days after the applicable statute of limitations had ended. Now, while that statute of limitations was running on the plaintiff's claim, so while time was clipping along, the Florida Supreme Court issued 6, count them, 6 administrative orders that tolled the statute of limitations for all claims in Miami-Dade County for various periods of time. And those tolling orders were related to 5 hurricanes and 1 tropical storm that hit the state of Florida, again, in the early 2000s. I think most of us will remember that time, and it makes a lot of sense that the Florida Department of Revenue was tolling limitations periods for those affected in Miami-Dade County. So the plaintiff in Ramirez, remember, they filed their lawsuit 3 days late. So he was just trying to get 3 extra days, and we just get it just over the line. So the plaintiff was arguing that those administrative orders added extra days onto the limitations period applicable to his claim. Right? He didn't need much time. He just needed 3 days. So this is certainly a creative argument. But the third district rejected this argument, holding that to toll, and I'm quoting here from the Ramirez case, to toll means to suspend or interrupt. There is nothing intrinsic to the language that requires tacking extra days at the end of a 4-year period. That's what the third DCA held. So the third DCA is holding in this context, in the context of administrative orders, now again, not a statute, but administrative orders that told a statute of limitations that it didn't add on extra days to the limitations period that would otherwise have run. Now, that was the third DCA opinion. There was an appeal to the Florida Supreme Court. This is interesting because the Florida Supreme Court initially granted review of the Ramirez case, but later relinquished jurisdiction. So a little bit of a procedural yo-yoing, if you will, on this case. A little bit odd, but not unprecedented. But what you have here is that you have the Florida Supreme Court issuing an opinion relinquishing jurisdiction, but you have a concurring opinion to that opinion relinquishing jurisdiction authored by Justice Pariente. And for those following along, if you want to look it up, you can find this opinion from the Florida Supreme Court at 37 Southern 3rd 240. That's 37 Southern 3rd 240. That's from the Florida Supreme Court in 2010. And this concurring opinion, of course, it's not binding authority, but it is persuasive, I think, for at least how one sitting Florida Supreme Court justice thinks. She wrote, in part, that the purpose of the administrative orders that told the statute of limitations would not be served if a litigant could tack on days to a statute of limitations where the last weather emergency occurred 6 months before the expiration and the litigant does not allege that delay in filing was based on any of the weather emergencies. So that's Justice Pariente saying, now the purpose here of these tolling provisions wouldn't be served by tacking on extra days. And then, of course, as in the section that I just read, paraphrased a little bit, if the reason for the delay wasn't tied to the reason for the administrative orders. I mean, you could go down that rabbit hole to see whether that applies to the statute in question. I would just set that aside for the moment and just illustrate here that Justice Pariente is saying that it wasn't the purpose of a tolling period to add more time. It was instead, if you read between the lines here, to allow people that needed to file things extra time to file them within the tolling periods. I think that's a justified way to read this and read the Florida Supreme Court's, at least one justice's statement on the facts in Ramirez, along with the underlying third DCA opinion. It makes sense that a tolling period then would not add more time on to a statute of limitations time frame that would otherwise run. So that's the Ramirez case, not a tax case, not a statutory tolling period. I realize that, but the reasoning there would seem to apply very strongly to the statutory tolling period that we have here under Chapter 213. Because we don't have any legislative statement in that statute that it's meant to add more time on to an audit. Instead, you just have a tolling provision. And it makes sense that you would need that kind of tolling provision, especially in the sales and use tax context, because otherwise audits of the full 3-year period would be functionally impossible. I mean, the department just couldn't audit. So that's one way to look at it through the lens of Ramirez. We have another case here that may shed some light on this, and that is the case of, get it correctly, Harris Corporation, Harris Corp. Versus the Department of Revenue. This is an older case, so we got to go back to the Southern Second, which I grew up with. That would be in 409 Southern Second 91. That's 409 Southern Second 91. And that case is from the Florida First District Court of Appeal from 1982. So we're going back to the 80s. Nostalgia time with this Harris Corp case. Now, in this case, you have, this is a tax case, and it's even a tax statute of limitations case, which is neat. But the statutes were different back then. The statute that was in place was worded differently than our current tolling provision. The tolling provision in effect back in the early 80s was worded differently than our tolling provision that's currently in place under Chapter 213. And the tolling period was different as well. Instead of the 1-year period that we have right now, it was a 2-year period that got added on. So in Harris Corp, you had a somewhat similar set of facts. And the somewhat similar issue of law, I should say. So the issue here was whether the department's assessment against the taxpayer was time barred by the applicable statute of limitations, or whether the limitations period had been tolled in a way that extended that period by 2 years. So this is the issue, isn't it? This is the issue that we're grappling with under current 213. So the statute in place in the Harris Corp case was the version of Section 95.091 that was in place in 1979, or even going back to the 1970s. So what this tolling provision in the statutes said was that except as otherwise, well, this was actually in Chapter 95. Now it's in 213. So you got the 3-year limitations period, but the tolling provision stated that, however, this 3-year limitation shall be tolled for a period of 2 years by a request for inspection and examination of a taxpayer's books and records by a taxing authority within that period. So you have a 2-year tolling period. So here, the assessment in Harris Corp, again, issued under that 1979 version of this tolling period, which was then in Chapter 95. It was issued 2 years and 5 months after the taxpayer notified the taxpayer, after the department notified the taxpayer of its intent to conduct the audit. So the department here, so you have this 2-year tolling period that was triggered by sending the notice, right? And you have the department issuing the assessment 5 months after they sent that notice. So this is just the same factual situation, isn't it? It's the department issuing an assessment after a tolling period has gone by. And the question before the first DCA is whether or not the department could still take advantage of the entire 3-year limitations period as well as the 2-year tolling period, essentially creating a 5-year assessment window. We want to not say period again, assessment window. So the department's position here was that after the 2-year tolling period under the statute had expired, that it still gained the benefit of the full 3-year statute of limitations as if the 2 intervening years had never happened. So effectively, the department's position was that the tolling period extended the limitations period from 3 years to 5. The first DCA rejected the argument. The court held that the tolling period was only effective if the department completed its audit within 2 years. So it was only effective if the department completed its audit within the tolling period. So the tolling period would only be effective if the department completed its audit within that tolling period. The court based its decision on the second clause in the tolling provision, which stated that in which event the period for which the tax may be determined and assessed shall be 3 years immediately preceding the date when the request for examination of the books was issued. The court held that this language required the department to make its assessment within 2 years of its request for inspection if it's to take advantage of the tolling provision. So the first DCA here in Harris Corp linked the tolling provision in the statute to the department's duty to complete the audit within that period that the tolling provision covered. So to state it differently, in the event that the department did complete the audit within the tolling period, then the limitations period would be calculated as if it had run while the department was conducting that audit. So here, the department in Harris Corp could no longer apply the tolling provision because it issued its assessment outside of that 2-year window. So the statutory limitation period reverted to 3 years as if there had been no intervening tolling of time. Therefore, when the assessment was made, only those taxes that were due within the statute of limitations, which would be a bare 3 years from the date of the assessment, back 3 years, would be due, or would be subject to assessment, right? So that's the option 2 that's essentially being endorsed here in Harris Corp. Now, the modern tolling provision in 213.345 is similar to the one from 1979 construed in Harris Corp. It's similar specifically because it has this language that says, if you recall back, the department has to issue a notice of intent to conduct an audit or investigation of the taxpayer's account, I'm quoting here, within the applicable period of time. That's in the modern statute. So what does that mean? Well, if we look at it through the lens of Harris Corp, which was construing the language that said within that period, that's very similar to within the applicable period of time, it would seem that a logical reading of the current statute in light of Harris Corp, and in light, frankly, of Ramirez, is that the tolling period only applies if the assessment is issued within the tolling period of time. That means within that 1-year window. So, given that case law, given Harris Corp, given Ramirez, given the common law idea that taxing statutes are construed strictly against the government, it seems that the stronger argument is that if an assessment comes out after the 1-year limitations period has expired, then option 2 would apply, which would mean that the first 12 months, or however long it was, before the department issued an assessment, would have essentially become time barred. It would have evaporated from the department's ability to assess those months would have evaporated. Because the tolling provision acts more of a safe harbor, more as a safe harbor than as an extension of an otherwise applicable limitations period. So, given that law, and of course I'm going to own this opinion, I'm going to own that it's my interpretation, and I'm not saying it's infallible. I think it'd be interesting to see counter arguments. I think a harmonious construction of the statute of limitation and the tolling statute would lead to a conclusion that when the tolling period ends, the department and the taxpayer are in the same position that they were before the tolling period began, which would mean that each party would be subject to an unadorned 3-year statute of limitations that requires the department to determine and assess each taxable month within 3 years of the date that the tax return for that month was due. I think that makes sense. So this means that the tolling provision of Section 213.345 allows the department to assess tax for a 3-year period based on the notice of intent to audit if now, the department issues its final assessment within 1 year of sending that notice. So if the department does not issue the final assessment within that year, the statute of limitations should be calculated as if the tolling period had never occurred. And I think that's what I have to say about that. So we are about 5 minutes away from our 50-minute hour. So let me read you the CLE course code right here, and then we'll unmute the lines to see if we have any questions or commentary. So once again, get your pens and pencils ready. The CLE course code is 17029110N, as in no. Once again, that's 17029110N, as in no. And Rachel, if you wouldn't mind. Okay, we are unmuted. Anybody have questions, comments, concerns, counter arguments? We would love to hear them.
Thank you.
Okay, well, hearing none, I think we've got it. Rachel, is there anything else we need to do?
Nothing at all. Thank you so much for presenting today. We really appreciate it.
All right. Thank you again for all your help, and thank you everybody that joined the call. Y'all have a great day.
Thank you.
Thank you.